Hi, this is Brett Sankis with Sankis Law and Brayton Woods, and today we're covering indemnification in the M&A context. So, indemnification 101 for mergers and acquisitions. Indemnification is an agreement between parties for one of them to be responsible for things that happen later on and to cover those on behalf of the other party. So it's a mechanism for parties to share risk. It's commonly used in commercial contracts. Let's say I am a salesperson for you and I'm out there and I'm talking to customers and I'm signing them up and I get a little bit of a commission. I might ask you to indemnify me if any salesperson is upset about the product or service I sell to them. And the idea might be, hey, I didn't make the product or service, you're fulfilling it. If I misstate something, maybe, but absent that, if we all get named in a big lawsuit, you got to pick this up and take care of it for me. So that's kind of the general idea. It's commonly put into a purchase agreement in the M&A context, and the buyer will indemnify the seller, and the seller will indemnify the buyer for any breaches of the representations or warranties in the agreement or breaches of the covenants. So representations and warranties are statements of fact. And a seller might say, there is no litigation and my financials are materially accurate. And there's all this sort of discussion and negotiation. The bigger the deal, the more discussion, negotiation around what these things say. But in the final purchase agreement, there will be representations the seller makes to the buyer and the buyer makes to the seller. And then there'll be covenants, which are agreements to do something in the future. So if there's a breach of one of those after the fact, the other party, right? Typically it's the buyer coming after the seller and saying, hey, you agreed to indemnify me. You agreed to indemnify me for any claims that came out of a misrepresentation that was incorrect, right? So if I'm the seller and I say, there's no litigation in my business, and there turns out that there was, I didn't know about it, I didn't tell you about it, I mean, all sorts of things. That's a whole other issue. Not telling someone it can just be fraud, but let's just say I didn't even know about it and I made a statement that said there is no litigation, as opposed to a statement that says, to the best of my knowledge, there's no litigation. So let's say I say there's no litigation. Turns out there was, and I just hadn't been told about it. Someone had filed a lawsuit on my company the day before we close. You can come to me and say, hey, you agreed to take care of any issues that come out of that misrepresentation. So now I need to step up and take care of the damages. So I would make you whole. And indemnity's a little different. So if you would have a claim anyway as the buyer because I've just breached a contract. So under general contract law, you have a claim. Indemnities are more unique than that. A lot of times we're shifting liability that you wouldn't otherwise. One party might not be liable for under contract law and they're shifting it to the other party. But in this context, you would have a claim, but the indemnity carries additional benefits. Often, it carries the right to be defended in the lawsuit. So whereas if you didn't have an indemnification, you would have to go and you suffered a loss, right? You're fighting this lawsuit and you end up losing, then you've got to come after me and you've got to say, hey, take care of this or sue me. The indemnity obligation allows you to just send over to me a notification that, hey, we've got a claim, and this claim is something I believe is covered by the indemnity, so are you going to honor it? And I've got to step up and run the defense and hire the lawyers and pay for it. So indemnity is a more fulsome thing than a contract damage. Very common in deals. The only time you won't see indemnities really is going to be maybe, well, occasionally they're just not put together in that way, but there are some deals where purposely they're not there. Public company deals and things like that where there's no one to go back after the fact. In other words, a big public company is selling business to a buyer. Well, public companies are held by, thousands, tens of thousands of private individuals and institutions and things like that. The buyer of that business can't come after those selling shareholders. That's not possible. So there might not be indemnification in that context. And that brings us to a second part of indemnification, which is, let's just say we have that kind of concept generally. There will be, usually very explicitly, we will talk about how long the indemnity is good for. And we talk about it in the context of how long will the representations and warranties survive after the closing? And how long will the covenants survive? So what that means, if your M&A lawyer does their job well or is able to get to the finish line with this approach, and we usually are, all of a seller's liability is compartmentalized in this indemnity clause. It's very clear. There's nothing else. You can't sue me for anything else. It's all right here, Mrs. Buyer, if you have some sort of a loss. and we'll say the representations and warranties that the seller makes will last for X number of years. The covenants will last for this amount of time. Although covenants, these go forward promises, usually last kind of forever, or as long as they need to be, as long as the promise is good for, as long as the parties expected it to last. But the representations and warranties, when I represent sellers, I'm looking to limit those. I'm looking to limit the survivability so that at some point in time, my selling client knows they can just move on and they don't have to worry about anything else popping up. It's very common that the survivability will be chopped into two different buckets. And the first one will be something like, commonly 2 years, anywhere between 1 year and 4 years, but 2 is pretty common, maybe 3. And it's these representations survive for 3 years. And then there'll be a different bucket of representations that survive for some other period of time. And that's usually things like taxation, sometimes environmental issues, or things that are much bigger items, may take a lot longer to find out about. So these are commonly considered to be, they might be called fundamental representations, or they may be called extraordinary, or there'll be sort of a different term for them. And in the case of tax, for example, it will often say all those representations survive for 2 years. That tax one survives until the statute of limitations runs. The idea here is the seller may have no idea, the buyer may have no idea there's a problem until the IRS brings it up 6 years later. So the idea is, look, most things, breach of contract, I should find out about pretty quickly. That's fair to limit it to 2 years, but something where the IRS has a long reach and can come back way after the fact, that should survive for a longer period of time. So you have this sort of like limited period, and then you have these others that survive for longer. Some of them, things like a representation that says, I own the shares I'm selling to you, or the business owns the assets it's selling to you, are considered to be fundamental representations often that survive indefinitely. Indefinitely means indefinitely. But the idea here is, look, that's something that you should not possibly get wrong. Like, how do you know? How can you not know if you own those shares? How can you not know if the business owns those assets? You have to know if someone else is making a claim to them. It's just not much to ask you to just promise that forever. Whereas these other representations, like litigation, for example, the idea is like there could be, you might not know. And it really depends on the language of the representation. They can be very, very nuanced, and there's sort of a shifting of risk among buyers and sellers for how things are stated. But it's reasonable for a seller's position to be, look, I'll take the risk by telling you there's zero litigation, but I guess I don't really know if someone filed something yesterday. And so at some point in time, that's not a great example because obviously that will come up pretty quickly. But there's other situations where it's like, look, at some point I just want to be able to move on, right? So you've got those ones that are limited usually, and then you get this other bucket of either very fundamental things that you should just never get wrong, or things that are better tied to a statute like environmental and tax because they can come up way later on. Okay, so in a public company context, sometimes the reps and warranties don't survive at all, right? Which kind of begs the question, why do you even have them? And you don't have very many in those deals oftentimes because there's no one to go back after if it's a stock sale. Basically, it's all these people, all these shareholders, thousands of shareholders, and the seller doesn't even know who they are, right? Like, what are you going to do? But in a private M&A deal, the reps and warranties, they always survive. I've never seen them not survive. I've seen them be highly limited, but they almost always survive, and they're often chopped into two buckets. So other concepts that are really important as a seller, and I guess they're very relevant as a buyer, are called the cap, and then either a basket or a deductible. So the cap is an absolute limit on what you could be out of pocket as a seller for a indemnifiable claim. So if there's a representation, if I make a representation as a seller that there's no litigation, I sell my business for $5 million. Turns out there was a lawsuit filed the day before, and that lawsuit ends up costing the buyer $10 million, right? Oftentimes, my out-of-pocket costs will be limited. And in the mid-market, sort of upper mid-market, like bigger deals, $100 million, $500 million sort of deals, it's a cap is often, I think statistically 10%. That's the kind of where it comes in there. In smaller business world, what I call Main Street, which is $2 million or under, or the lower middle market, where we do a lot of work, is up to 25 or 50 million, just depends on who you talk to. In there, caps are usually higher. The idea is just like in absolute dollars, 10% of $1 million deal is only $100,000. It's not much protection for a buyer. Whereas a $100 million deal, it's still $10 million, right? So everything's relative, but then it's not. In other words, that would still be a heck of a claim to show up after the fact that no one knew about. So caps are really important from a seller's perspective. I always go after a cap, and we try and get as low as we can. And in Main Street world, it's not uncommon to see them be 20%, not uncommon to see them be as high as 100%. Yeah, it's a little bit on the higher side, I would say, but it really depends on industry. It depends on the business, how clean it is. There's a lot of factors that go into this, but you do, as a seller, want to try and limit your liability, just to know you're going to walk away with something, or even at 100%, you're not going to actually have to pay out because your business is gone, and now if there's some claim you didn't know about, you've got no revenue and income stream to pay it off with. So caps are very important just to try and limit total exposure. And obviously, as a seller, the lower the cap, the better. There are often carve-outs to the cap for fraud and intentional misconduct kind of things. So they're really just things that you would have no defense on as a seller. If they can prove if a buyer can prove you defrauded them, there should be no limit. That's the idea, and that's a pretty hard thing for a seller to argue against. Another concept that comes up, it's kind of related to the cap, but is a deductible or a basket, or more commonly called a tipping basket. And this, unlike the cap, which protects you on it can never be more than X, the deductible is like what it is in car insurance. It's actually the opposite, right? In that case, it's you pay the first $100 or $500 of damage. Here is you don't have to pay that as a seller. Or you could look at it, the buyer does have to assume that risk or pay that or take that loss personally. So those are commonly around 1%, 0.5% to 2%, something like that. That doesn't vary as much by deal size in my experience, but the idea here is, hey, you're buying a business and you've got to take some risk, and we don't want to be nickel and diming each other. I don't want to see a bill for $100 here and $1,000 there. So a deductible says the seller is not responsible even for a truly indemnifiable claim until the losses exceed X amount. And then the seller is only responsible for the first dollar in excess of that threshold, and then from there on up. A tipping basket says, okay, seller, you're not responsible for the first $10,000 of claims, but if we get to $10,001, you're responsible for all of it. So that's this idea that it builds up in a basket. If it goes $1 more over, it tips, and the seller's entirely responsible for it. Which is better? Generally speaking, buyer's going to want a tipping basket, a seller's going to want a true deductible. The idea, generally speaking, the idea is that the buyer is going to have incentive with a tipping basket to start looking for nickel and dime things to trip it, and the deductible is, from a seller's perspective, more consistent with the purpose of the deductible, which is for the parties not to be nickel and diming each other. But that's just a negotiated item, and some of that's a little bit of a matter of preference, and there are arguments in each direction. So, but as a seller, really important to get get that number as high as possible, get the cap as low as possible, get the survivability pulled in as closely as possible, and then just be really, really careful about the representations you negotiate and what you disclose and how you put that all together. So this stuff is super complex, but it's very nuanced, and there's, I've been doing this for 20 years, and every day I learn things. I mean, there's always little additional things to peel back. But from your perspective as a buyer or seller of a business, it's not so complex that you can't get your hands around this stuff pretty quickly. So if you have questions about this, if you're dealing with this, reach out. We'd love to help out. If you have a comment, certainly drop it. I'm interested in your position on this stuff and what you see in the marketplace. So thanks for stopping by today.